So there's this extraordinary moment that happened in mid-2025 that I think we're still processing. Actually, it wasn't just one moment. It was two deep shifts in international law that landed within weeks of each other. First, in early July, the Inter-American Court of Human Rights delivered the most comprehensive advisory opinion on climate change and human rights ever written. Then, just a couple of weeks later, on July 23rd, the International Court of Justice, or ICJ, the world's highest court, issued its own groundbreaking opinion on states' climate obligations. Two of the world's most powerful international courts in the span of a single month, fundamentally reshaping how we understand the legal obligations around climate change. But to understand why this moment mattered so much, you have to go back 20 years. A group of lawyers and Inuit indigenous leaders filed the first ever human rights petition on climate change, targeting the US government for violations stemming from global warming. The response? It was summarily dismissed, not just by the Inter-American Commission on Human Rights, by some human rights practitioners themselves. The legal world simply wasn't ready. What happened next is this remarkable story of transformation that some scholars call the rights turn in climate law. Over the next 2 decades, nearly 500 rights-based climate cases were filed worldwide. Courts from Germany to Brazil to South Korea started recognizing that climate change isn't just an environmental issue. It's a fundamental human rights crisis. And then 2024 became a watershed year. Another international court, the European Court of Human Rights, ruled that Switzerland's insufficient climate policies violated the rights of elderly women, particularly vulnerable to extreme heat. Suddenly, climate inaction wasn't just disappointing policy. It was a human rights violation with real legal consequences. That same year, in Barbados and Brazil, the Inter-American Court convened unprecedented multi-day hearings, bringing together hundreds of lawyers, scientists, advocates, and youth leaders from across the Americas. For those of us presenting to the robed judges, it felt like climate change itself was on trial. So when the Inter-American Court's opinion dropped in early July 2025, it didn't just build on that 20-year history, that 20-year evolution. It propelled it forward. First, the court declared that the obligation not to cause irreversible environmental damage is a peremptory norm of international law that cannot be abrogated or derogated from. Think about that for a moment. Think about what that means. The court elevated climate protection to the same normative status as prohibitions against torture, the highest level of legal obligation that exists. Second, the court became the first regional human rights tribunal to recognize the rights of nature itself. Not just human rights to a clean environment, but nature's own right to maintain its essential ecological processes. This is huge. The court reasoned through environmental obligations in an ecocentric way, rather than in an anthropocentric way, recognizing the intrinsic value of non-human beings and ecosystems. Third, the court recognized a distinct right to a healthy climate, which compels states to protect the global climate system. And the judges didn't stop there. They explicitly addressed corporate obligations, requiring emission disclosures, climate due diligence across entire value chains, measures to prevent greenwashing. The court also emphasized something crucial that often gets overlooked: comprehensive adaptation strategies. The judges recognized that significant global warming is now locked in, so states must not only mitigate but also adapt without creating new vulnerabilities or harming ecosystems. Then, just weeks later, the ICJ consolidated this robust framework spanning multiple areas of international law. The ICJ said states have binding duties that flow from the UN Charter, human rights law, the law of the sea, and fundamental principles in customary international law. But here's the key insight. They tied it all to science. The court said governments must act in line with the best available scientific knowledge. That is, the reports of the Intergovernmental Panel on Climate Change that set the limit of global warming at 1.5 degrees. Suddenly, climate science is not just policy guidance. It's a legal standard that can be enforced. And the ICJ reiterated what the Inter-American Court had said. Climate change violates human rights. The right to life, to health, to food and water, even the rights of future generations. It also spelled out the consequences, saying states that fail to meet these obligations may be held internationally responsible, including potential reparations. Now, here's what's fascinating about the timing. The lawyers, advocates, scientists, and citizens involved in the nearly 500 cases leading up to these decisions created legal momentum. Advocates and courts built on each other's reasoning, creating this upward spiral of legal protection. And there's something profound about this sequence coming from the Global South first. The Inter-American Court's jurisdiction covers countries where climate impacts are already devastating. Rising seas, extreme droughts, unprecedented hurricanes. The court wasn't theorizing about future harms. It was responding to present emergencies. Another remarkable feature of the process leading to these landmark decisions is the key role played by civil society organizations. For instance, young people from the Pacific Islands were the driving force behind the campaign that resulted in the ICJ opinion. Their effort was both imaginative and effective. They traveled the world for years and ultimately persuaded governments to request the court's opinion on climate change. So why does this convergence matter so profoundly? First, it transforms the entire landscape of climate litigation. Courts in Amsterdam, Brasilia, Seoul, Delhi, they can now point to multiple international authorities providing detailed roadmaps for climate obligations. Second, it fundamentally reframes governmental accountability. For decades, climate action felt aspirational, voluntary, subject to political whims. These opinions say, no, this is mandatory. There are binding legal obligations, and there are consequences for failure. Third, and maybe most importantly, it creates new pathways for climate justice. Small island nations facing extinction, indigenous communities losing their territories, vulnerable populations bearing the brunt of extreme weather. They now have concrete legal theories for demanding not just action, but reparations. But what I find most striking about this moment is how it represents law catching up to moral and scientific reality in real time. These courts weren't just interpreting existing law. They were recognizing that the survival of humanity on a habitable planet has become what the Inter-American Court called a universal value that law must protect. The courts have given us something unprecedented. They've recognized that human rights are embedded in and dependent on the rights and well-being of the more than human world. Future climate law should embrace this holistic vision, connecting climate with biodiversity, with rights of nature, with economic justice. International law usually moves slowly, but in this case, it moved faster, and legal frameworks shape political possibilities in profound ways. They create new narratives for activism, new tools for accountability, new expectations for what governments and corporations and citizens of the world owe to current and future generations. We'll see these opinions cited in courts from Geneva to Bangkok. We'll see them raised at the climate summits. We'll see the next generation of climate lawyers and advocates wielding them to accelerate climate action at a time when we need it most.